their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentence.
Today's case is a bit different. We have a sovereign citizen in court who seems utterly convinced that she is above the law. Throughout the hearing, she keeps interrupting the judge and arguing with the officers, clearly thinking this will help her case. Spoiler, it doesn't. The most interesting part? The judge is absolutely unshakable. He doesn't tolerate her interruptions or antics for a second. This is a judge who means business, and he quickly puts her in her place. By the end of the hearing, the judge delivers a sentence so decisive and firm that she clearly didn't expect it. Watching her unravel in real time as the judge maintains total control is both intense and, frankly, a little entertaining. As we watch, it's hard not to wonder about her reasoning, or lack thereof. You can't help but question just how much thought went into her actions today.
The date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis. By the way, turn it off.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now. Turn it off.
Yes, it is, Justin.
This is exactly what happens when someone who believes the world revolves around them is suddenly confronted with reality. In her mind, she's the victim, and it's obvious from the way she carries herself. You can practically see the lifetime of entitlement and audacity in her behavior, walking into court and yelling over the judge like that. No ordinary person would do it, especially knowing the serious consequences they could be facing. This isn't something you just decide to do on a whim. It's clearly a pattern that's been reinforced over many years. If I had to speculate, it seems likely that her upbringing played a role. Without trying to psychoanalyze anyone online, her behavior gives off the classic signs of someone who might have grown up with an absent father. That kind of experience can shape a person's sense of authority and boundaries, and in her case, it seems to have fueled this defiant attitude.
Why you allowing that?
I'm finding you're your own lawyer. He's not your lawyer. He's nothing going to do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, these cases all of those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So,
I don't want to participate in this. Y'all have to let me go.
Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
Out of here. I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom, a victim, I think, I'm not sure.
No, Your Honor, she's
No, they're not.
outlasted the victims.
So I'll ask the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes.
That was about to fall.
She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor.
For the U.S. court system.
She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new case. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here,
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge
Hold
that.
on, I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up?
No.
You're not? Okay.
But I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
No.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement.
All right, stand by. Apparently they're gonna restrain her and bring her back in. Thank you. All right.
This what y'all brought me in here for?
All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement,
I didn't run for no police.
and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up in the legal. The court lacks jurisdiction over the subject matter.
Someone needs to get her under control. Honestly, if she weren't behaving like a toddler having a meltdown, she probably wouldn't be strapped into that chair, looking completely unhinged. And when I say unhinged, I mean it. She's full-on lost it at this point. Just look at her. If there were a psychological study on sovereign citizens, she'd easily be the poster child. You almost get the feeling she could have started the whole movement herself. The most ridiculous part? she's wasting the time of 7 officers. 7. That's half a police squad tied up babysitting this train wreck, while real crimes are happening somewhere else. Somewhere out there, someone's car is probably getting stolen, and yet all resources are devoted to keeping her in check. Honestly, they should send her a bill for all the manpower she's draining. It's probably more expensive than that fake diplomatic immunity card she bought online. Despite all this, the officers are incredibly patient. You can tell they're fed up, but they handle her with professionalism and restraint. After dealing with this circus, I'd personally be asking for a raise. Handling this level of chaos deserves serious recognition.
Year enhancement, I can't remember that.
It is, I'm sorry, Your Honor, it is 708D, and I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-707?
Yes, I'm sorry, ARS 13708.
It's illegal.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims' presence. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D.
If you're enjoying this kind of content, don't forget to hit that like button and subscribe to the channel. It really means a lot and helps keep these videos coming. Now, let's jump back into the action.
Further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the 2nd degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the 2nd degree, of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and this is a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did he give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all we're going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay.
The wildest part about all these sovereign citizen cases is that it's almost become normal to see them. Every day there seems to be a new video of someone claiming to be above the law, yelling about maritime codes, and getting hauled off in handcuffs. A lot of this behavior seems to stem from bigger social issues, political chaos, fractured families, and a lack of guidance growing up. Honestly, I wouldn't be surprised if many of these people spent more time watching conspiracy videos online than learning basic life skills, like following the law. Now, they act as if they can declare independence from reality and escape consequences. In spoiler, they can't. Sovereign citizen logic holds about as much weight in court as a get-out-of-jail-free card in Monopoly, which, honestly, would probably be more effective than their arguments. Judges have consistently ruled that claims like diplomatic immunity, strawman theories, or renouncing citizenship carry zero legal weight. It's basically a game of legal Jenga. They pull random pieces of nonsense, and eventually it all collapses on them. This case was intense, and honestly, it's been a long time since I've seen someone act like this in court. I'd love to hear your thoughts. Drop them in the comments because I always enjoy reading what you all have to say. Take care, and I'll see you in the next one.